120 words per minute. Get ready. Start. While dealing with a claim petition in terms of section 166 of the Motor Vehicles Act, 1988, a tribunal stricto sensu is not bound by the pleadings of the parties, semicolon, its function being to determine the amount of fair compensation in the event an accident has taken place by reason of negligence of that driver of a motor vehicle stop. It is true that occurrence of an accident having regard to the provisions contained in section 166 of the act is a sine qua non for entertaining a claim petition, but that would not mean that despite evidence to the effect that death of the claimant's predecessor had taken place by reason of an accident caused by a motor vehicle, the same would be ignored only on the basis of a post-mortem report vis-a-vis the averments made in claim petition. Stop para. The deceased was a constable. Stop. Death took place near a police station. Stop. The post-mortem report clearly suggests that the deceased died of a brain injury. Stop. The place of accident is not far from the police station. Stop. It is, therefore, difficult to believe the story of the driver of the bus that he slept in the bus and in the morning found a dead body wrapped in a blanket. Stop. If the death of the constable had taken place earlier, it is wholly unlikely that his dead body in a small town like Dharmapur would remain undetected throughout the night, particularly when it was lying at a bus stand and near a police station. Stop. In such an event, the court can presume that the police officers themselves should have taken possession of the dead body. Stop para. The learned tribunal, in our opinion, has rightly proceeded on the basis that apparently there was absolutely no reason to falsely implicate respondent numbers 2 and 3. Stop. The claimant was not at the place of occurrence. Stop. C, therefore, might not be aware of the details as to how the accident took place, but the fact that the first information report had been lodged in relation to an accident could not have been ignored. Stop para. Some discrepancies in the evidence of the claimant's witnesses might have occurred, but the core question before the tribunal and consequently before the High Court was as to whether the bus in question was involved in the accident or not. Stop. For the purpose of determining the said issue, the court was required to apply the principle underlying the burden of proof in terms of the provisions of section 106 of the Evidence Act, 1872, as to whether a dead body wrapped in a blanket had been found at the spot at such an early hour, which was required to be proved by respondent numbers 2 and 3. Stop para. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter, stop. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. Stop. The claimants were merely to establish their case on the touchstone of preponderance of probability. Stop. The standard of proof beyond reasonable doubt could not have been applied. Stop. For the said purpose, the High Court should have been taken into consideration the respective stories set forth by both the parties. Stop para. The court restated the legal position that the claimants were merely to establish their case on the touchstone of preponderance of probability and standard of proof beyond reasonable doubt cannot be applied by the tribunal while dealing with the motor accident cases. Stop. Even in that case, the view taken by the high court to reserve similar findings, recorded by the tribunal was set aside. Stop. Following the enunciation in Bimla Devi's case, within bracket supra bracket close, this court in Parmeshwari within bracket supra bracket close noted that when filing of the complaint was not disputed, the decision of the tribunal ought not to have been reserved by the high court on the ground that nobody came from the office of the SSP to prove the complaint. Stop. The court appreciated the testimony of the eyewitnesses in paragraphs 12 and 13 and observed thus. Stop para. The other ground on which the High Court dismissed the case was by way of disbelieving the testimony of Umed Singh, PW1. Stop. Such disbelief of the High Court is totally conjectural. Stop. Umed Singh is not related to the appellant, but as a good citizen, Umed Singh extended his help to the appellant by helping her to reach the doctor's chamber in order to ensure that an injured woman gets medical treatment. Stop. The evidence of Umed Singh cannot be disbelieved just because he did not file a complaint himself. Stop. We are constrained to repeat our observation that the total approach of the High Court, unfortunately, was not sensitized enough to appreciate the plight of the victim. Stop.